All right, today we got Business Law Today, which is a terrible, terrible name for a book because what about tomorrow? Sorry, I thought it was funny, so whatever. And when was this written? Or when was it published? (2008). Okay, so Business Law Today from 2008. You understand why I don't see that this is the greatest of chapters or names for a book. All right, today, 12, 13 years ago. All right, contents in brief. Oh, I like how they do the little units though. They're like little mini books. You see them with the picture? It's dark outside today. It's kind of, I got the light overhead giving a horrible shadow. It's hard to see. All right, the legal environment of business, contracts would be number 2. Number 3, sales and lease contracts would be number 3. Number 4, negotiable instructions. Number 5, debt creditor relationships. Number 6, business organizations. 7, government regulation. 8, prosperity and its protection. And 9, the international legal environment. Now, honestly, all this stuff is great. You can never go wrong with a law book or a statistics book, right? I mean, economics, okay. Because times kind of change. I mean, with law changes too, right? But for the most part, it doesn't, right? Majority of this stuff is the same as back in olden days. But economics, very different, right? And it's just very different. Let's go. Chapter 2, constitutional law, right? 34. Now, as we know, this is a textbook, so I will be reading this from the Ruta to the Tuta, right? And be giving my synopsis, kind of in-depth review for each chapter, break it all down. Oh, I found something. The impact of foreign law in the United States. As noted in the text, the United States Supreme Court interprets and gives meaning to the rights provided in the U.S. Constitution. It is the court's role to determine the appropriate balance of rights and protections stemming from the Constitution. Clearly, this is a difficult task, in part because society's perceptions and needs change over time. The justices on the Supreme Court are notably influenced by the opinions and beliefs of U.S. citizens. This is particularly true when the court decides cases involving issues of freedom of speech, religion, obscenity, or privacy. Changing views on controversial topics such as privacy in an era of terrorist threats or the rights of gay men and lesbians may affect the way the Supreme Court decides a case. But should the court always consider other nations' laws and world opinions when balancing individual rights in the United States? Over the last years, justices on the United States Supreme Court have exhibited an increasing tendency to consider foreign law when deciding issues of national importance. For example, in 2003, for the first time ever, foreign law was incited in a majority opinion of the Supreme Court. References to foreign law had appeared in footnotes and dissents on a few occasions in the past. The case was a controversial one in which the court struck down laws that prohibited oral and anal sex between consenting adults of the same sex. In the majority opinion, an opinion that of the majority of justices of side, Justice Anthony Kennedy mentioned that the European Court of Human Rights and other foreign courts have consistently acknowledged that homosexuals have the right to engage in intimate consensual contact. This comment sparked debate in legal circles over whether the Supreme Court or other U.S. courts should ever consider world opinion or cite foreign law as persuasive authority. I never really thought of it that way. The practice has many critics. including Justice Scala, who believes that foreign views are irrelevant to ruling on U.S. law. Other Supreme Court justices, however, including Justices Breyer, Ginsburg, and O'Connor, who is now retired, believe that our increasingly global community, we should not ignore the opinions of courts in the rest of the world. That's good. Long live Ginsburg. She passed. I don't know if you guys, that to me, that was interesting. It's actually really interesting. I don't want to read. All right, because this is all about, it's under constitutional law, and it's all about speech, right? Corporate political speech, commercial speech, and unprotected speech. The United States Supreme Court has made it clear that certain types of speech will not be given any protection under the First Amendment. Speech that harms the good reputation of another, or defamatory speech, Chapter 4 if you want to learn more, will not be protected. Speech that violates criminal laws, such as threatening speech, is not constitutionally protected. Other unprotected speeches includes fighting words or words that are likely to incite others to respond violently. Now, here, remember, this is the unprotected speech. The First Amendment, as interpreted by the Supreme Court, also does not protect obscene speech. Establishing objective definition of obscene speech has proved difficult. However, and the court has grappled from time to time with this problem. In 1973, Miller versus California, the Supreme Court created a test for legal obscenity, which involved a set of requirements that must be met for material to be legal obscene. Under this test, material is obscene if the average person finds that it violates contemporary community standards. The work taken as whole appears to be prudent, arousing, or obsessive interest in sex. The work shows patiently offensive sexual conduct, and the word lacks serious remedy, literally, artistic, political, and scientific merit. Because community standards vary widely, the Miller test has had inconsistent application, and obscenity remains a constitutional unsettled issue. Numerous state and federal statutes make it a crime to disseminate obscene materials. However, the Supreme Court has upheld such laws, including laws prohibiting the sale and possession of child pornography. Well, yeah, that makes sense. The First Amendment also does not protect statements that assert facts. Unlike an opinion, a statement of purported fact can be verified and may require proof in a suit based on a claim that the statement is defamatory. In the following case, the issue was whether or not a certain statement was an unprotected factual assertion. So, freedom of speech, say whatever your opinion is, make sure that it's not obscene. Because if you have a fact, you better be able to back that fact up.